Hello everyone, this is Sherrod Seward with Queen City Immigration Law Sports Practice, and today we're going to talk about the nitty-gritty, well, a little bit of the nitty-gritty details when it comes to obtaining P-1 visas for esports athletes. Typically, when you're doing a P-1 visa for an athlete, there's certain things that are kind of set in stone, which are easy for immigration attorneys to navigate. So let's take the example of a player that has a contract with the NBA. So first of all, they have a contract with the NBA, which automatically makes them eligible for the P-1 major sports visa. And that's appropriate for organizations that have over $10 million in revenue. And all you have to do basically is show them the contract, and USCIS is like, okay, we get it. And then also, those same leagues, the player associations, will issue a no objection or a consultation letter, which is halfway towards getting the P-1 visa right there. So if you're a typical NBA player, you're halfway, actually 3/4 of the way to getting your P-1 visa, just because you're signed to the NBA and the Players Association will write you a no objection letter. Now, the no objection letter is important because there's 7 criteria that USCIS looks at to make sure that you are P-1 visa eligible. And one of those is the consultation letter. So if you already have that, then you just have to prove one of the others, which could be something like playing on a college team or a national sports team. Now, the issue that a lot of immigration attorneys are having with esports is that there is no major league and there also is no organization to get these consultation letters. And then you also have to deal with the fact that USCIS is not always consistent with calling esports games a sport, which is another hurdle. And so what I'm going to talk to you briefly is about the 4 major things that need to be proven for a successful P-1 visa for an esports athlete. The first thing is the sponsor. Because it's not a major sports league, you have to prove that the sponsor has a need for international talent for whatever event, league, or tournament that they're putting on. The second thing is you have to, in every petition, is prove that esports is a sport. So every successful esports attorney, immigration attorney, should have a template that basically outlines the history of esports as a sport every time and not take it for granted. The second thing is that even with esports being a sport, you have to look into that particular game, that title that you're playing. So while esports might be consistently seen as a sport, maybe there's a new game that comes out that hasn't been presented to USCIS, or that particular adjudicating officer has never seen that game before. You need to be able to prove that that game is a sport within the esports umbrella. And then finally, you have to get into the individual acumen and international recognition of the person playing the video game that is an esport for the petitioner that needs international athletes. So as you can see, this can be a quite convoluted argument that has a lot of ways to fail. It's very easy to not be successful for an esports P-1 because of these 4 things that I talked about. So the first one is the petitioner. The petitioner needs to be an organization or a person that has need for international athletes. So if you have a large tournament where they can show there's been international participation, that's a great start to say, hey, we've already had international athletes that's won prizes and been given P-1 visas before. The problem comes a little bit more difficult when you have new tournaments that's never been put on. So they've never experienced having international athletes play at these tournaments and get them done. And so an experienced immigration attorney, and one that's savvy, would have a couple tips and tricks up their sleeve to be able to show that a fresh new tournament is in need of international players. And even if there's a lot of money behind the tournament, say for example, the Overwatch League had a myriad of issues when it came to visas. And this very well might have been one of those problems, is that the petitioner wasn't properly explained to USCIS that they need international athletes. Second, we get into the issue of whether esports is a sport or not. Now, we know that it was a Canadian esport player about 5 years ago that was issued the first P-1 visa, but just because they were issued one doesn't mean that USCIS automatically recognizes every esport athlete as an athlete. You must painstakingly go through the process of showing the history of esports, their participation in it worldwide, and making great arguments that it is indeed a sport every time, just to make sure that whoever is the adjudicating officer, whether they're new to USCIS or they've been there for many years, or whether they are, kind of apprehensive about calling esport a sport or not, prove your case. Third, we need to look at the actual game. So we know that esports encompasses professional video games, but not every video game is played at a professional level. It's for this reason that not only must you prove that esports is a sport, but that particular game is played at a professional level that deserves the attention of USCIS to approve a P visa. Many ways to do this. One thing we do is we look at previous tournaments that's been done in this game. We kind of make sure that this game is similar to other games that have already been approved. We look at tournament pools. We look to other countries to see if their federations have been forward and positive about recognizing these particular games within esports as indeed a sport that is competed at the professional level. And then finally, after we build our case with the structure that there is a competitive event that's going on that's worthy of international recognition, only then do we look and build the case for the individual international recognition of the athlete. Now in esports, this is going to be particularly tough because there's no players association to get the consultation letter. As I stated before, there's 7 criteria that USCIS looks at to establish P1. And some of them are very subjective, some of them are objective. Of the objective ones is if you have a consultation letter from a players association. Since that's out of the ballpark, we have to deal a lot with these subjective categories. Some of those include if you've played college. College is a good one if you've been on a college esports team, or if you competed on a national team for esports. And again, this is subjective too, because what exactly does a national team mean? And it's the job of a great immigration attorney to go and make that argument for USCIS. Other subjective arguments that need to be made is whether there's experts in the field, usually media people or consultants that are relatively well known to write opinion letters on your behalf. The others are international rankings. We can also look at your earnings compared to other athletes in the sport. And there's other things that we can look at to make sure that you are known as an internationally recognized athlete. And an experienced immigration attorney that's used to not having the, helpful resources of a players association or a major league contract would know how to do this. But again, remember there's 4 things that need to be proven for an effective esports P1 visa application. 1 is the petitioner needs to exhibit that they need international athletes. 2, we got to prove that esports is a sport every time. 3, we need to prove that the game being played is competed at a professional level. And 4, we need to prove the international recognition of the athlete without the help of having a players association or a labor association to help us out with a consultation letter. For more help, just give us a call at our law firm. We're pleased to give free consultations to any esports athlete or team looking for our services.